The broadcast is now starting. All attendees are in listen-only mode.
Good morning and welcome to the #MeToo Sexual Harassment in the Workplace webinar. I'm your moderator, Denise Ketty, and I wanted to go over a few quick housekeeping notes before we introduce our expert panel. The webinar today is going to run approximately 60 minutes in total, and there'll be time at the end of the webinar to address some of your questions. If you have questions during the presentation, please post them in the Q&A area on the dashboard. If you haven't done so yet, take a moment to download the presentation, and there's 3 actual handouts in the handout area that you can download today. Just a reminder that today's webinar is being recorded and all the accompanying materials are protected by copyright. The presentation today provides general information and does not constitute legal advice. We recommend that you consult with your own legal counsel to address your specific situation and needs. The #MeToo, or I should say the #MeToo sexual harassment topic is extremely important as we are witnessing the fallout from sexual harassment complaints across all industries. Fortune magazine reported that the #MeToo was used more than 500,000 times on Twitter, and Facebook had more than 12 million posts in just the first 24 hours when the hashtag was created back in mid-October. And we all know those numbers have grown exponentially in the last few months. So what can you do to protect your company and employees? Well, let's get the conversation started by welcoming our expert panel today. Our legal expert today is Marla Merhab Robinson. Marla is partner and head of transactional department at Merhab Robinson, Jackson & Clarkson. Marla's reputation among her clients and peers is that she is responsive, reliable, and respected. And what sets Marla and her team apart from most other legal firms is that she and the members of her team have all worked in the corporate world, so they understand the challenges that business owners face on a daily basis, in addition to understanding all the legal concerns that your businesses face. Our next presenter is Linda Duffy. Linda is president of Ethos Human Capital Solutions, and Linda is known as the people problem solver. She develops strategies for business leaders to get the right people, systems, and culture in place in their organization. Linda and her team are strategic advisors who help business owners with human resources, consulting, recruiting, and training. And Ethos is celebrating their 10-year anniversary this year. Thank you both for being here today. Linda, why don't you get us started this morning?
Awesome. Thanks so much, Denise, and welcome everybody. We've got a great agenda today. Go through and talk about, as Denise mentioned, a very important topic, and we hear about it in the news all the time. So it's not like this topic is new. It's just that we're now hearing about it a lot more because of everything that's been in the news and some, prominent people that have been accused of sexual harassment. So we're going to talk about sexual harassment laws, the criteria for harassment. Marla's going to be talking about the different types of harassment that exist and what employers can do to defend themselves. We'll also look at some pretty serious liability for both some people in the company as well as the company itself. And then I'm going to talk about the effects on the workplace and the company responsibilities, and then share some best practices that we believe will help the company stay compliant with the law but also create a respectful workplace. As Denise mentioned, this is not going to be legal advice today. It's not a course on the law. We're going to touch on that. And of course, Marla is an expert in that, but because not everybody on the call is a client, please don't take this as legal advice. Also, we may use stories or use language that would otherwise be inappropriate in the workplace, and we'll do that just for educational purposes. So we're just using that disclaimer up front. No intent to offend anybody, and of course, we would never do that for any purpose other than educational, but we just want you to be aware that we might, in answering a question or in telling a story, say something that otherwise we normally would not consider to be appropriate. I love this little cartoon here just because it's such a good reminder of all the big names that have been accused of sexual harassment over the past year, and this is just a fraction of them, right? As Denise said, these are such important issues in the workplace, harassment and also discrimination. And there's liability for employers, for supervisors, for managers, and even for coworkers. So not a day goes by that we don't hear about sexual harassment in the workplace. And it doesn't have to be only based on gender, although that's really what our focus is going to be today. So before we get into the content, we are curious to know whether the Me Too movement has impacted your company. So we have a little poll that we're going to launch here. And we just want to know, have you guys seen a difference in the number of claims that you're seeing brought forward, the number, of people coming forward? So go ahead and just click one of those boxes. Either yes, we've seen a dramatic increase in complaints, or a little bit, maybe people are more aware and they're starting to voice some concerns, or nope, hasn't done anything for us, hasn't changed a thing. And we're just curious. So we've got just a little bit over half the people voted, so the rest of you will give you just another couple seconds here to weigh in on this and see. Looks like right now, not at all is in the lead, with about 70% of the people voting. Take one more pause here just to give people a chance to weigh in. Okay, great. We have 75%, and then I'll share the results here. So you can see very few people are saying that there's been a dramatic increase in complaints. And I would have to say, I don't know, and Marla can weigh in on this in a second. For us, I would say that's really similar. We have had clients certainly call us, and we continue to do sexual harassment investigations and a lot of training. There have been a couple of issues that have popped up, but I would say very little. I would agree, though, with the people that said people are more aware of harassment. I would say that's definitely true, which is a great thing for everybody. And I'm happy for the people that say not at all. I'm glad that nothing has changed in your world, and hopefully this today will offer some best practices to keep it that way. Okay. So with that, I am going to turn it over to Marla and let Marla start talking about the different laws that affect this environment.
Thank you, Linda. I'm guessing that we're getting a lot of not at all here because these are people who are proactive. You're all on this call and this webinar because of that, and I applaud you all, and also especially since many of you are my clients. I know you're doing this right, and Linda's clients as well. So there are many laws that govern workplace behavior, and they come from many different places. There's federal law, state law, the state constitution. There can be local and municipal laws. For example, San Francisco had a sexual orientation prohibited discrimination before we even had FEHA, and we've seen that in the wage and hour areas as well. So it is possible. You would need to check local and municipal laws depending on where your company has employees. And then, of course, we always get law from our judges and our juries that we call case law, and even company policy. It doesn't create laws, but it can create claims. So it's a little bit uncharacteristic here. It's not really where law comes from, but it can create claims from your employees, contractual claims, if you've provided a promise to them and it rises to the level of a contract. So let's first look at the federal law governing sexual harassment, because we're not going to spend a lot of time with that one. If laws conflict, the highest standard will prevail, and California's got the highest standard in the land when you compare it to federal law. So the federal law is Title VII of the Civil Rights Act, and it prohibits discrimination against a job applicant, a current employee, or former employee. Unlike California, it does not prohibit discrimination against unpaid interns or contractors or volunteers. California does. And it also only affects employers in commerce with 15 or more employees. And it's enforced by the Equal Employment Opportunity Commission. So if you have an employee who's going to bring a claim under federal law, which would be very rare because they have more protection under California law, but for some of you who have employees in other states, it might not be as rare. They would do that through the EEOC. The primary, and not the only, but the primary California state law that provides protection here is the Fair Employment and Housing Act, which those of you who've been on our webinars before know we discuss quite often in other areas, but it prohibits discrimination and harassment, which is a form of discrimination, based on a wide range of characteristics. It also requires companies to prevent discrimination and harassment. You have an affirmative duty to prevent it, and Linda will discuss later what that means and how you can do that for those of you who aren't sure. But this lists a lot of the protected classes here, which we're going to provide you a more thorough list a little bit later, and the California law under the FEHA is enforced by the Department of Fair Employment and Housing. So if you have an employee who wants to bring a claim under FEHA, they will file that first with the Department of Fair Employment and Housing. And it affects all employers, unlike the federal law. The second state law that might be impacted is, of course, the Constitution, which prohibits disqualifying an employee or an applicant based on sex, race, creed, color, national or ethnic origin. Again, the protections against discrimination and harassment as a form of discrimination. The newest state law, just adopted in July of last year, is really a part of FEHA, the Fair Employment and Housing Act, and just updated that. So it's not a separate law, and it's on gender transitioning. It adds a definition of transitioning, which is the process some transgender people go through to begin living as the gender with which they identify, rather than the sex assigned to them at birth. It may or may not include changes in name and pronoun, bathroom facility usage, participation in sports activities, hormone therapy, sex reassignment surgery, or other medical procedures. This is, again, brand new, so we will get more definitions as additional regulations come out. We will also see some interpretation in the cases. But the point here I would like to drive home is that gender should not be a factor in any employment decision. And in the harassment context, to let you know that you can be liable for slurs that are related to gender stereotypes. Slurs would be a verbal form of harassment. We'll get into some more examples later. So the protected categories, protected classes, which I'm going to give you on the next slide, there's over 20 of them for federal and state laws, and they're all protections that can rise to the level of harassment discrimination, not just based on sex. So here's our list. Is there anything missing? People ask me all the time, is this protected? And I said, well, let's pull out the list and look at the list, because it is not exhaustive. There are some things that aren't here yet, but may get here over time. And the changes we've been seeing in the most recent years, again, as we just discussed, are all related to gender and sexual orientation. So the new transgender regulations that I just discussed were effective this year, so that's how new they are. They were adopted last year, but they went into effect this year. And it's really important to know these protected categories because it's how we determine whether or not there is illegal harassment. The most common calls I get are about bad behavior, which can even be very offensive to some or all, definitely unprofessional. So we call it bad behavior or inappropriate behavior for the office or warehouse environment, any work environment, but it may not rise to the level of illegal behavior. And that's when we need to go back to these protected classes and say, was the behavior tied to one of these protected classes? To rise to the level of illegal behavior or unlawful, as we're going to talk about in just a minute, it must be tied to one of these protected classes. And the most common one I hear is, you know, the person with the foul mouth who's running around screaming obscenities, while very offensive, very unprofessional. Unless it's tied to one of these protected classes, it won't rise to the level of unlawful or illegal. But as you can see, because we have so many protected classes, it's very simple to do that. For example, you could have the person who only screams and yells at women because, and it could be a woman screaming at women, but because they might be considered weaker. Or you could even just have them screaming, you're weaker. That could rise to the level of a protected class. So the goal here is to avoid any conduct that could create potential liability in the first place. Not to say, oh, we're not worried about that conduct, even though it's inappropriate, offensive, because it's probably not illegal. We want to avoid it all. We don't want to have a claim because it's very expensive to defend these claims, even if we know at the end of the day that there's not going to be any liability. So let's talk about the illegal harassment. It must involve a protected category, as I said. It must be offensive, unwelcome conduct that concerns the protected classes and is so severe or pervasive that affects the terms and conditions of employment. So let's talk about severe or pervasive, because a lot of people don't seem to understand that. When I do the training, which I haven't done in years, I've turned it all over to Linda's firm, I always put a big X on the screen and write the word severe at the top left-hand corner and pervasive at the top right-hand corner, and switch them at the bottom. If something is very severe, for example, a touching is considered very severe. I had an employee for one of my employers who walked down the hallway, grabbed someone and kissed them. That's very severe. It doesn't have to be pervasive, meaning it doesn't have to happen a lot. Just once is enough. If it's not very severe, for example, maybe a joke. I told you a joke, an inappropriate joke tied to one of those protected classes, but I only did it once. That's not pervasive. It doesn't happen a lot. It might not rise to the level that is necessary for unlawful or illegal harassment. Again, may have been inappropriate, or, to use the judge's language in Paula Jones's case against Bill Clinton, boorish, but it might not rise to the level of unlawful harassment. Now, if I tell that same type of joke over and over and over and over again, and an employee is subjected to listening to it, then it becomes pervasive, and the severity doesn't need to be there. So that's the test of the severe or pervasive under the definition of unlawful harassment. It also, to be unlawful, must be related, as we talked about, to a protected category, and unwelcome. Now, this is a trick one here, because what may be unwelcome at first can become unwelcome. The very first reported sexual harassment case was about a couple, employees, a man and a woman, who had a relationship to start. And this is a very common story in the sexual harassment cases we defend. Originally, it was very welcome. It was consensual, as they say in the cases. However, it changed. She decided she wasn't in wanting to have a relationship with this man anymore. He was her supervisor, and he started changing her hours of work and changing her working conditions. So what I always advise employers when they're looking at what language is welcome or unwelcome is you don't know. It may appear to be welcome to me on the outside, and on the inside it might be killing me. And this is often what we see in the jokes and in the cartoons, and that somebody might be appearing to play along, and yet inside it's really not acceptable to them. It's very unwelcome. And the common teaching is if you don't know, don't do it. So if you don't know whether it's welcome or not, then don't engage in the behavior, and don't allow your employees to engage in the behavior. Offensive is the same type of thing. You need to know whether or not it's offensive to the person, and you don't know if the person might not even be telling you the truth because they're concerned about losing their job. The courts do use a reasonable person interpretation on the offensive part of it, and then again, severe or pervasive. The offensive has to be both subjective and objectively offensive, however, even though we're using a reasonable person standard. Next slide. Sexual harassment can be verbal or physical, and please add to your slide visual, because visual would be an example of calendars, which used to be very popular in warehouses, cartoons. Now it's, web emails. Used to be faxes. Back in the 80s, we were always getting in trouble for faxes. Verbal is, clearly speaking, and then physical can be the touching, and unfortunately, we see this all the time as well. I gave you the example of the gentleman who grabbed the gal, gentleman, I shouldn't use that term, I guess, and kissed her without permission. So it can be in any of those forms, verbal, physical, or please add to your slide, visual. And it must seriously impact the employee's job or be used as a basis for employment decisions about the employee. Again, the unwelcome nature, if you don't know, don't do it, and that's what you should be telling your employees. Sexual harassment can be by a woman against a woman, by a man against a man, by a woman against a man, and by a man against a woman. We in our office have defended all of these. There is no discrimination. Sexual harassment does not discriminate against anyone. It can happen against anyone, and I would now throw into that, since we have all these gender regulations, all the other LGBTQ as well. It can be anyone against anyone, and it can take many forms, as we've just said. So there are two types of harassment. The new terms for this are economic harassment and environmental harassment. I've always known them by their old terms. The first is quid pro quo, and the second is hostile work environment. Now, quid pro quo means literally something for something. So if I ask you to do something for me, and in exchange, I'm going to give you something that's related to your employment. So for example, I'm going to ask you to give me sexual favors, and if in exchange for that I'm going to give you the best hours, or I'm going to give you a raise, or I'm going to give you a promotion. It's a tangible employment action. Any significant change in your employment status, a hiring, a firing, a demoting, a promoting, failing to promote, reassigning, assigning hours, anything that's a change in benefits. When it's negative, it's a direct economic harm, and that's when it becomes economic harassment. Now, hostile work environment, that's the more difficult one. And again, the reason that's more difficult is because of the unwelcome nature. We don't know what's welcome or unwelcome. We need to deal with severe and pervasive. And what may be harassment may not, again, be unlawful or illegal harassment. It may be unprofessional, unwanted, and boorish, but it may not rise to that unlawful or illegal if we don't have the unwelcome contact whose purpose or effect unreasonably interferes with the performance of the employee and rises to that level. So let's talk about what this means in terms of liability to the companies and the managers. So there can be personal liability as well as company liability, and that's something that really needs to be communicated to your employees when Linda starts to talk about training, because people act differently if they know that their personal bank account, their homes, their cars, their boats, their jet skis, their 401ks could be subject to personal liability, including sometimes defense of these crimes, which can be very expensive if you're paying attorneys $450 to $500 an hour. Let me just briefly tell you the definition of a supervisor, because it comes up often too. It's anybody who has authority on behalf of the employer to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline. My point here is it's a lot. If you have a lot of if you have the ability to take a lot of action on behalf of the employer, then you will rise to the level of a supervisor. And the reason why that's important is because employers or companies are strictly liable for damages an employee incurs as a result of a supervisor's sexual harassment. And the bar is not quite as high if it's a non-supervisor or a contractor, because you can also be responsible for if the UPS person comes in and harasses your employees. Unfortunately, we've had that happen. Or FedEx. I'm not going to just attack one and not the other. And then the person who's committing the harassment can be personally liable. So where it says many states, including California, allow supervisors to be held personally liable for engaging in acts of unlawful harassment, add to that and other employees as well. Because if you were the employee who is committing the harassment, you can have personal liability. Now, supervisors do not have personal liability for failing to stop it if they're not the ones committing it. We have case law to that effect. However, they should have responsibility. They're going to have disciplinary action against them by the employer. So in December of last year, we had the Tax Cuts and Jobs Act adopted, and it included a section which prohibits deduction by employers for any settlement, payout, or attorney's fees related to sexual harassment or sexual abuse if it's subject to a non-disclosure agreement. Now, the media, if you've been listening to all the Me Too movement and all the claims of sexual harassment, call them non-disclosure agreements. We call them confidentiality agreements. And so if you've got a confidentiality or a non-disclosure provision in your agreements, you need to be advised about this inability to deduct. Sometimes these settlements are quite large, and it may be more important to be able to take that deduction than it is to have the employee be silent about it. So it's something to discuss with your CPAs or your accountants because previously it wasn't restricted. Okay, as I said earlier, third-party harassment, you can be responsible for the actions of third parties, such as agents of yours, contractors of yours, and even those who aren't yours. For example, UPS, vendors, suppliers, customers, volunteers, interns. And as I stated earlier, federal law doesn't cover all of those, which is why we often see more of the cases coming under state law than we would federal law. So, excuse me, the newer should have known standard. Courts may hold the employer or supervisor liable if the supervisor or employer knew or should have known about the harassing behavior. On the supervisor, as I said earlier, on case law is not finding them personally liable, but it's going to hold the employer liable. And again, this is another reason for the training that Linda's going to talk about later. One of the really premier cases in this was EEOC versus Murphy Motor Freight Lines, where it was a federal case where the court found a violation of Title VII because the supervisors knew or should have known of co-workers' harassment of black employees, but they didn't take any action to stop it. So the company was held liable for that. Now, I have often asked about questions about off-duty conduct, and if it's a supervisor engaging in off-duty conduct, that can certainly lead to that same strict liability. So even though they're not at work, which is why we have a lot of times non-fraternization policies, and sometimes we allow fraternization because we have to if we're in an industry that, like the tech industry, where everybody's dating pool is at work because everybody's young. We have consensual relationship agreements where we advise of the company's sexual harassment policies and the law regarding the same. So the next slide says defenses, but it's a little bit inaccurate because the first bullet is the federal courts do have a defense that you can avoid liability where there is no adverse employment action, no firing, no transfer, that type of thing. If the employer took reasonable steps to prevent the sexual harassment and to promptly address sexual harassment in the workplace, and if the victim was unreasonable in failing to take preventative action, for example, advising supervisors or going into HR. That's a defense in the federal courts. California courts, this is not a defense, the avoidable consequences doctrine, so I apologize for that on this slide. It can limit liability, so you can underline that. It's a liability limitation, not a defense. So the difference is the employer can be found liable. A defense would get rid of liability. But this avoidable consequences doctrine can limit that liability, in other words, limit the amount. So it can reduce the damages awarded if the employer takes reasonable steps to correct and prevent the workplace harassment. Again, Linda will discuss that. If the employee was unreasonable in failing to take measures provided by the employer, like you would have in your handbook, go see HR, talk to your supervisor, talk to the owner. And if the employee had reasonably made use of the employer's procedures, then at least some or all of the harm would have been prevented. So you have to show that as well. It's a high standard, but it can be met, and then that can reduce the amount the employee would be given once liability has already been found. And with that, I hope I didn't take too long. I'm going to turn it over to Linda.
You never take too long because we all learned so much from you, Marla, including me, and that was my bad on the defense part. It was my attempt at being brief on the header, so I apologize for that. So thank you so much for that, Marla, giving us that background and that insight into the law and what everybody should be looking out for. So obviously it's really important because there's a lot of damages, and I mean this in a couple different senses of the word. Certainly financial damages, but also just how it impacts the workplace, and it impacts the person suffering the harassment. So of course they can be awarded dollar amounts for all these things you see on the slide, and especially punitive damages are what we always hear about in the news. So I think everybody probably knows what punitive damages are, but it's a big old slap across the face is what it is by the jury wanting to send a message to somebody, to a company, or to a person that they think really deserves something. So you'll hear stories about, the loss of wages was $100,000 and all of a sudden, but the jury verdict was 50 million in punitive damages or something extreme like that. And it's meant to send a message, and that's why it ends up in the news. So the other thing to keep in mind is, in addition to all of the laws that Marla was talking about and the actual charges or complaints filed against a company based on the harassment, there's other laws and potential claims that could come into play here. So for example, when we do this training, we use some examples of blocking somebody's exit from a room, which would be potentially false imprisonment. Certainly, some of the stories we've been hearing in the news about an assault could result in a rape allegation, right? So there's other things that go on here as well. And we've had situations where this gives rise to a workers' comp claim, right? So it could impact other things, not just the direct harassment that we've been talking about. Now, I just did some training for a client this week, and I left this slide in our training today, our webinar today, because I wanted to point out something really critical here. So I took this from the EEOC website, right? It's their press releases. These are all open to the public. So first of all, you've got to think about the bad PR for your company if you end up on their website. But the other reason I left it in is because this is from just 11 days. Okay, just 11 days. So starting January 23rd and then going through the 2nd of February. These are all the different announcements they had about various suits that they've brought against companies or settlements they've achieved with companies. And look at some of the names here, because one of the things I hear from clients all the time is, oh, well, such and such big company does this, so it must be okay. Not specific with reference to harassment, but just in general, they feel like, oh, well, if the Cheesecake Factory does it with all of their employees and their management team, then it must be okay. But look, Cheesecake Factory got themselves into trouble. Kentucky Fried Chicken is listed. Lowe's Home Centers is listed here. So I don't want you to ever think just because you hear of another company doing something or not doing something that means that it's okay, because they get it wrong too. And as Marla said, this is also, she didn't use this phrase, but I always say it's in the eye of the beholder, right? So you don't know what's going to be unwelcome. You don't know what's going to be reasonable to somebody else. And so they could be doing something completely above board and chose to settle these matters just to get rid of them. I'm not saying that Cheesecake Factory or KFC or anybody did anything wrong, but it's something to be aware of. Don't just rely on the fact that another company does something as making it okay. Now, sex harassment charges are on the decline at the federal level. So you can see the numbers here. 7,900 charges were filed in 2010. EEOC just released the stats for last year, and it's dropped down considerably, which is great. As Marla said, we'll see if that goes back up over the course of this year. But also remember, employees may file complaints either at the state or the federal level. And just so everybody understands how easy this is, for employees at the state level, all they have to do is go to the DFH website. It used to be they had to go walk into an office to file a complaint, and now everything's just done online. At the end, when they fill out, the company's name and your name as their supervisor, and they talk about, all of the horrible things that, that they had done to them, then they answer a simple question, which is, do you want us to investigate this on your behalf, or do you want us to close out your claim and give you what's called a right to sue letter? And that basically gives them the ability to check the box to say, yep, I went through my administrative remedy first, and I went to the DFEH, and now I just want to go straight to my attorney and sue you guys. It's so easy to do. So it's really critical to make sure that we have open communication in the workplace to prevent employees from going outside the internal complaint process. You want to make sure that you're always taking any sort of complaint that's brought to your attention, or you're addressing anything you see in the workplace before it escalates to that level. Hopefully, we can nip it in the bud, avoid that, and make sure that we're just creating a workplace where everybody feels comfortable working. One of the things that we see all the time in complaints, if you look at the stats either at the California or at the federal level, is the #1 complaint being filed is workplace retaliation. And so that, we all know what that is, right? We're getting even with somebody, we're getting back at somebody for doing something. And so what happens a lot is this is filed as a standalone claim, and also it's filed on top of an underlying claim. So you sexually harassed me, I complained about it, and then you retaliated against me for complaining about the harassment, and now they have both of those complaints in one filed against you. Another way it comes up is, let's say somebody comes forward and says, I've been sexually harassed by my manager, and then so-and-so, my two coworkers here, know about it as well. I told them about it, or they witnessed something, and then those two employees are retaliated against by the manager for participating in an investigation, or by just being interviewed or something like that. So those two employees, even though they weren't sexually harassed, could bring the complaint for the workplace retaliation. It's the #1 complaint, like I said, at the federal and state level, and it's more than doubled in the last 20 years. So it is something that you want to make sure that you're always aware of, that you're not taking action against the person who's coming forward with the complaint, and you're not taking any action against other people who are participating in the investigation. So, as I said, in addition to the monetary damages and everything else that can be awarded, we just got to really focus on how it can impact the workplace. And it really can create problems for employees and for their coworkers, but for the company overall. And so usually when I do this training, I tell a quick story. And the story is this: a long time ago, I worked at a company that was in the high-tech arena. This goes back quite a few years, and the company actually had just gone public and decided the way to kick off their new year, fiscal new year, was to fly in all of the salespeople from around the world. So right there, we should have had a red flag, but fly in all the salespeople and tech support people from around the world, and then send them on a 3-day weekend turnaround cruise to Ensenada, where they were going to have some meetings and they were going to kick off the new year and do some strategic planning and some training and some team building. And long story short, by the time that Monday morning rolled around and they were all headed back on buses to the company, I was getting 2 different types of phone calls. Some people were calling saying, oh, we had such a good time, this was great, but those old fuddy-duddies, they just were sticks in the mud, they just didn't know how to have a good time. And then we had calls from other people saying, I need to see you right away, I'm not sure I can continue to work at this company, I need to see you right away, I've been sexually harassed. And so fast forward, we conduct an investigation, we look into everything, and there were so many different incidents you can't even imagine, a lot of alcohol involved on this, but we had situations where we had, essentially the vice president of sales condoning and participating in different things going on in the ship in various stages of undress, people doing jello shots and passing them mouth to mouth in the pool. We had one woman pull down the top of a coworker out on the deck around the pool. So when all was said and done, we agreed that what we would do is actually terminate the employment of the vice president of sales and the female coworker that pulled down the top of the other female coworker. And keep in mind, this was done within a month or so of going public, so it was a pretty big deal. But I was also really proud of the company for taking what I felt was the appropriate action and not trying to sweep it under the rug. But think about how long it took for that sales team to work together as a team again, right? We had people that literally said they were afraid to be in the building early with the VP of sales after what they'd witnessed, right? And you've got now 2 camps, right? People that participated and people who didn't. So it's just something to keep in mind in your organization is, all of the consequences it has on the work environment and how it's going to impact the team for weeks or months to come. So the company certainly has different responsibilities. I'm going to go through each of these separately. So there are some training requirements, posting and pamphlets, policies, and then also we want to touch on investigations. So with regard to the training, I think most people probably already know this, but just as a good reminder, if you have 50 or more employees, then there is a requirement to provide your supervisors, and Marla talked about that definition, supervisors and management personnel with 2 hours of mandatory, quote-unquote, interactive training every 2 years and within 6 months of being hired or promoted. This is training that we do all the time, and we can also do it in Spanish. We can do it via webinar. So if you haven't done this training or it's time for a good refresher, just reach out to us. The training has to now include a component on abusive conduct as of a year ago or 2 years ago, and also now must include a discussion on harassment based on gender identity, gender expression, and sexual orientation. Now, there's no requirement to train all employees, but I'm sure Marla would agree with this, we would all recommend that that's what you do. It's your first line of defense, right? Coworkers need to know that they also have some liability. You want your employees to know what to do if they see something, hear something, witness something, whatever. If they, are subject to harassment, we want them to come forward. So we want to make sure that we're telling them what is bad behavior, as Marla said, or what's inappropriate or unlawful behavior, and then making sure that they know to come forward. There are posting and pamphlet requirements, and this will also help you communicate to your employees what's important and what to avoid. So there are 2 requirements here. If you're buying the poster like through CalChamber or something, which a lot of people do, where you have all of it in one, most likely these are included. We always give out the sexual harassment pamphlet. We recommend that regardless of the poster, that you hand out the DFEH 185 pamphlet. It's just a folded brochure. The transgender rights in the workplace is a poster that you have to post, so make sure you have up-to-date posters there. I uploaded both of these into the handout section of the dashboard, so if you were able to find the printout of the slides, you're able to find these as well, and of course you can just Google them and know that. Keep in mind that the one on the right, the DFEH 185, does talk about how to file a complaint, right, with the state of California. And so you want to be transparent about this, but you also want to make sure that they have avenues that they can pursue within the company as well to avoid that, hopefully. The other thing to keep in mind about these posters and pamphlets is that you do have a requirement that if more than 10% of your employees speak another native language other than English, then you need to provide that to them in their language. And if you go to the website, you'll see that they have it listed in Chinese and Vietnamese and all sorts of other languages. So you want to make sure that you're providing the poster to them in the format where they need. Okay, policies. So obviously everybody needs to have a discrimination, harassment, and retaliation prevention policy. In April 2016, however, there was a regulation, and I hyperlinked that, so hopefully people, well, you probably don't have that because I didn't email you the handout. So if anybody needs that hyperlink, just email it to me. But if you just Google this, you'll find it. So it's an April 2016 regulation on California discrimination, harassment, and retaliation prevention policies. And there are certain terms and conditions you must meet. You always want to include, like I mentioned, multiple avenues for reporting concerns. You don't want to say you must follow a chain of command, you must go to your boss first, because what if the boss is the one doing the harassment, right? So you want to make sure that they can go any place. They can go to any member of management. They can go to human resources. We provide some of our clients with a hotline where people can, make a phone call and report it to us. So there's a whole bunch of different options there, but you do have a requirement to provide this in writing to your employees, and you need to get a signature from your employees acknowledging receipt. You can put it in your handbook, but if you don't have a handbook, you want to make sure you do it as a standalone policy. And then also on the right, we've listed all of, most of the things anyway that have to be included in the policy itself. Now let's talk about investigations. Investigations, there's the law is very clear on the things that must be included in the investigation, how it must be handled. So we have a requirement, for example, that it be prompt. So the complaint can come from any source. You want to make sure you're, again, not requiring your employees to put anything in writing, which sometimes I hear people say. If you could witness something yourself that gives rise to a complaint, right? It doesn't have to come from the employee being harassed. You could say, wow, I didn't, I heard what this manager said, or I heard what this coworker said, and that crossed the line, and we need to address it. So that's what's meant by constructive. So if you have an actual complaint, someone comes to your office, they verbally or in writing say, I've got a complaint, I'm being harassed, or if you witness something or somebody comes to you and tells you they witnessed something, you want to make sure that you deal with it as promptly as possible. The person doing the investigation needs to be impartial. That's pretty obvious to me, but you'd be surprised. And that means someone who has no stake in the outcome. So if I come forward and I say, hey, my boss is harassing me, clearly my boss cannot be doing the investigation. My boss's boss may not even be impartial enough to do that investigation. So typically it's HR, or it's an outside consultant like us, or it's a private investigator, or it's an attorney, or it's somebody else who has no stake, no skin in the game. you want to make sure you're protecting the complainant as much as possible. We always tell people you can't keep 100% confidentiality because clearly you're going to be talking to the person that's being accused and doing interviews, and you're going to be saying, hey, you know, has this ever happened? And they're going to figure it out, but you do want to make sure you're protecting them from retaliation. So confidential to the extent possible, but absolutely no retaliation. You're going to do interviews. We normally, and we have a whole webinar on how to do investigations out on our Marla and I each have a YouTube channel, so if you go out and you look for her channel or look for Ethos HCS, you'll find a whole webinar on how to conduct these interviews. But you know, we're going to talk to the person that's bringing the complaint forward. We're going to interview any witnesses. We're going to look at any sort of evidence, whether there's emails or text messages or something like that. And we're also going to talk to the person being accused. We're going to determine who's credible. If there's no witnesses and there's, you know, and it's a he said, she said or something, we're going to determine credibility. Ultimately, we're going to draw some conclusions or determinations, and then we're going to issue an investigation report. And we usually issue memos back to the accuser and the accused, and it's also going to call for recommendations for remedial action. So, you know, we had a situation this week with a client. It wasn't sexual harassment, but somebody felt, we'll say, harassed based on religion. And so we talked about it and we said, okay, what are we recommending? Do we want to recommend, do we think any inappropriate behavior took place? Do we want disciplinary action? Does it warrant termination? No, in this case, you know, we brought the two parties together and sort of talked it out. And we also said, you know, we're going to do some training for the employees so they recognize what's appropriate behavior and how sometimes what they say, they don't realize how it affects other people. Okay, so let's talk about best practices to prevent harassment, and then this is a good time to remind everybody, if you have questions for us, which we'll have a few minutes to answer, type them into the question box on your dashboard. Normally the dashboard's on the right, and just scroll down until you see questions, and you can just pop something in there, and then Denise will be asking those of us in a minute. So best practices, you know, I could have listed 100 different things, but these are the ones we sort of came up with as most important. First of all, adopt a zero tolerance attitude toward harassment. Let everybody know, look, we're not going to tolerate any sort of harassment in our workplace, right? That starts at the top. If your CEO comes out and says, we're not going to tolerate this, and it flows down through everybody in the company, it'll be a respectful workplace if that's really what's going on there. You want to make sure you review and revise all policies for impact by harassment. Think about other policies that could come into play. For example, your social media policy, right? Are employees allowed to post things on social media? You can't really prevent what they do outside of work, although usually when we do this training, we talk about harassment in a 21st century, because you would have a duty to come forward, I believe, if you saw a manager maybe posting harassing things, even in Facebook outside of work, depends on what it is. So you want to take a look at social media policies. You want to take a look at your technology policies. You know, can employees use your computer system or a smartphone that you've given them and post things using it that would be inappropriate? Can they go, you know, look at websites that may be inappropriate? You want to make sure you're just taking a look at it all different angles, and then revise those policies accordingly. Your anti-harassment policy, you know, post it. Post the poster that you need to post, or hand out the handout. Discuss it at department meetings, you know, periodically. Even if you don't want to do a full training for all of your employees, certainly when you have department meetings, you could have your manager highlight it, ask them, you know, or remind them to come forward if they see something, if they experience something. Marla mentioned this, love contracts to limit exposure. So we use the euphemistic term love contracts, but consensual relationship agreements. That's for people that are dating. Now, I would always recommend that someone don't date a direct report. And if that's the case, then, you know, the company and the two individuals need to make a decision about who can be transferred where. But if you have coworkers dating with no direct reporting relationship, I would definitely suggest that they enter into this love contract just to acknowledge it's a consensual relationship and someone can't change their mind on that later. Invite feedback about the work environment, meaning you could conduct surveys, you can just ask people in small gatherings, just one-on-one, whatever it is everything okay? You know, how are you feeling about the work environment? Give them as many opportunities as possible to voice concerns. Pursue unprofessional behavior even among management. You don't want to cover anything up. You don't want to know something's going on and not address it. Anytime somebody comes forward, you want to make sure that you're addressing it, because otherwise it's going to be that big whammy at the end known as punitive damages because, oh, we knew about it, we just didn't do anything about it. Makes it a million times worse. Consider having a third-party hotline, such as what we offer to our clients, where people can call us with complaints. Have a transparent complaint procedure. Again, I've mentioned this a few times, to keep those issues in-house, and then by all means do regular effective harassment prevention trainings. So hopefully all of those recommendations are helpful to people. Of course, Marla and I are happy to help anybody if they need implementing this. And with that, I'm going to turn it over to Denise so we can take some questions.
Okay, that's a lot of information, really good information to have to protect your company and the people who work for you. As we mentioned, if you have any questions, please post them in the Q&A area and we'll do our best to answer all the questions. If we don't get to your question, we'll follow up with you later. I know that I think in one of the later slides you'll get the contact information if you haven't downloaded the presentation for both Linda and Marla in there. So if you have further questions that you want to address with them after the webinar, you can. So let me start with the first question, and we're going to go right to Marla. Marla, is there a statute of limitations on filing a sexual harassment grievance? We see a lot of things coming up because of the knowledge of the Me Too campaign. So can you go back, and how far can you go back?
So yes, to file a lawsuit against an employer for sexual harassment, an employee must first, if it's in California and it's from the FEHA, they must first file a claim with the Department of Fair Employment and Housing, and they have to do that within 1 year of the alleged violation. And that alleged violation can be the last time an unlawful act occurred. So sometimes that's difficult to determine. So I would say please talk to a lawyer about this. If it's under the federal law, remember you file with the EEOC, and that has to be within 180 days of the last alleged violation. If it's filed with either one of them, by the way, it's shared with the other. So the DFEH shares its claims with the EEOC and vice versa. And then a lot of times if there's an attorney involved, the attorney will ask that the file be closed right away and that the EEOC and the DFEH not continue their investigation and the possible filing of a complaint, because the attorney will do that right away, and they have a year to do that from the time they receive a letter from them saying that this is how much time you have to file. But before we jump to the next question, though, I just want to point out something about what Linda said when she was talking about recommending training. She may, that was one of the best practices, and it was also on an earlier slide, which is we recommend training for all employees, even though it's not required by law, and that's correct. The term training is not specifically addressed in the law to say, yes, you must do this. However, if you remember from one of my earlier slides, you do have an obligation as an employer, an affirmative duty under the law to prevent harassment. So how do you do that? How do you prevent harassment? Well, one way is training. So if you're not training all of your employees, I just want to strongly encourage you to do so, whether you use someone like Linda to do it or you use, webinars online, your HR department. I would strongly encourage you. It's one of our best defenses we can use when we're defending these claims. My firm does a lot of that, is to be able to say, look, this is the training that we do.
Okay, thank you. We have a question that came in, and both of you talked about love contracts. So is it that the company should have the love contract, and then you as an employee go to ask for the love contract? How do you handle such a situation, or what's the advice you give to employees that might start dating? Linda, I think.
Yeah, so when we do this training, we tell everybody, look, it happens, right? As Marla mentioned, high tech is notorious for this because you're at work like super long hours, and that's your dating pool, right? That's where you are. So what we always tell employees is, look, I don't think it's reasonable, personally. I don't think it's reasonable to say you can't date a coworker. I don't know if you can really legislate that, and the heart wants what the heart wants. But what you can say is, look, if you're dating a coworker, we want you to protect yourself, protect the person you're dating, and protect the company all at the same time by just acknowledging that it's a consensual relationship. And usually when we sit down with people and we explain that to them, it makes sense to them, right? Because the two parties involved, everybody's happy right now, they're in love, it's all great. But the potential exists for it to go south at some point in the future. Hopefully it won't, but you don't want to ever have that person that you once really cared about come back and allege that it was somehow an inappropriate relationship. And the company needs to make sure that especially if one of them's in a management position, whether it's direct or indirect over that employee, you want to make sure that there's no coercion going on, that there's nothing being promised or given to the employee in exchange, for sexual favors or for going out on dates or anything like that. So I think it's really important that they come forward, they tell HR, and then HR pulls the two parties together and has them sign off on this agreement.
So I'd like to just add to that, you can, and I do have some clients who do legislate that coworkers cannot date. And there are some, it's certainly not in technology, you would lose your workforce, but I have some clients that are private schools, some churches, that do have company policies that the coworkers can't date. Here's where it becomes very tricky. To Linda's point, the heart wants what the heart wants. Once you find out that they are dating, you have to make decisions and take action, and that action is going to be looked at very critically. Did you treat them the same? Did you terminate both? If you didn't terminate both or discipline both, why not? And did you discriminate on someone? Was it because of one of the protected classes that you treated someone differently? So it's important to have it in your policies, whether you're dictating that or not, and then if so, in practice, how you enforce that policy.
Okay, good information. One of the questions we just received was a person's CEO uses obscene profanity in the office as frequently as we would use the word "the" in a conversation. And it's been considered things have to be done her way, and that everyone just has to get used to this environment. At times, she's been known to say that people are stupid, idiots, weak, and wants to kill them. And most recently said, if a person can't stay after 5:30 to meet with me, I'll literally kill them. At what point, if any, is this considered harassment?
Wow, that's delightful.
I just can't wait to work at that place.
Well, let me go back and remind people of the definition that Marla gave you before, right? And the first thing we always look at is, does it involve a protected category? So staying after till 5:30 does not involve a protected category. One of the examples I use when we do this training is to say to people, like, let's say your boss comes to you every day, like every hour, and is really, as the employee would say it, harassing me to get my work done. Well, if it's just I'm pressuring you to get your work done over and over, come on, hurry up, hurry up, hurry up, that's, it's annoying, but it may not be harassment. But if I say, oh, you're so slow, you're so old and slow, now I've crossed the line because I have mentioned one of those protected categories. So I didn't hear any in the words that you used. I didn't hear any protected categories, so it probably doesn't give rise to that. It certainly could be considered bullying in my opinion, but there's no cause of action for that. But obviously you're going to have other bigger issues there, because the CEO's behavior, and I can't even imagine that being a very respectful workplace as a result. Marla, did you want to add anything to that?
Yeah, just a couple. And Lynn is absolutely correct. But remember when we gave you the list of the protected categories, it doesn't take much to claim that it's tied to one of those protected categories. I think she yells at the women stronger than the men, and that often sex, or men stronger than the women. It doesn't matter. I think she yells only at the people who she's not having a relationship with, and she has a personal sexual relationship, because remember, it's got to be tied to sexual conduct if it's sex with someone. It doesn't take much to get that, and usually people with this type of behavior that we've all identified as offensive, unprofessional, and according to the judge, boorish, it is a claim. the first claim, and then they'll stop because these, as we talked about earlier, these claims are very expensive. But also, the words I heard that could become something more that Linda touched on in one of her slides, additional laws and potential claims. You threaten to kill somebody.
Yeah, exactly.
That could be an assault under the law. You know, the definition of assault is the fear of being touched without consent. So if I'm afraid you're coming at me with a baseball bat to kill me, or whatever choice of weapon, or even your hands, that can be an assault. And so, you know, that's a claim that, by the way, your checkbook does not get rid of. That, you know, you have to deal with. The criminal justice system is a little bit different than the civil, and so you're dealing with district attorneys and defense attorneys. So, you know, I'm sorry for who's ever living through this, because I can't imagine anything worse than going to work every day and having to deal with that. But usually the behavior doesn't change until someone calls them out on it.
Yep.
Okay, I hate to say this, we have a lot of questions that we were unable to get to because this is such a hot topic, but we will reach back out to people and try to answer your questions privately. Linda, why don't you tell us what's happening next month?
Yeah, absolutely. So next month's webinar is going to be on March 15th, our usual time, 11 a.m. to noon. We're going to talk about the Industrial Welfare Commission orders. Say, what are those? You need to be on this webinar. So we get that a lot. Hopefully most people know what the IWC orders are, but it really does control how you need to conduct yourself within certain industries in California. So it's where a lot of the sort of the requirements are for employers on different things like overtime and alternative work weeks and other things like that. So we're going to walk you through some of those, help you figure out how you can judge which industry that you belong to, and so answer your questions about that. So hopefully you can join us for that, and I have the link to register right there, and we'll get that out to everybody also. Both Marla and I will get that out to everybody in our newsletters and in our webinar announcements. Okay, and with that, I'm going to say thank you to everybody for joining us today. We hope you found this useful. If we did not get to your question, then feel free to give me or Marla a call or email us, and our emails are right there. Thanks so much.